this place. So it is interestingly confusing, but yes.
Well, let me tell you something. I have a couple people in here that have continued to come back. And what we have done is now have them in facilities trying to figure out why they cannot stop picking up criminal cases. I'm telling you, I've got probably about 4 or 5 individuals that have kept with me. You now are on my list. So heed this warning.
Yes.
Do you understand, Mr. Castro?
So,
How do you plead to the offense of theft? Guilty or not guilty?
guilty, sorry.
I will find you guilty. I will sentence you to the agreement. Good luck to you, sir. All right, Josh.
Josh.
Oh, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. Just from now on. All right. So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was.
Well, it looks like the offense. So per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay. So when was that statement that I'm going to shoot up the house and yada, yada? Sure. Take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm going to find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm going to do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not going to go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right. All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure.
Morning, Josh. He speaks both English and Spanish, Judge, but he says he may feel a little more comfortable in Spanish.
I don't know if it's going to be a good, Mr. Martinez. I'm not happy with you. I asked you one thing. I have here that you're tampering with your device. Any alcohol detected?
No alcohol protection, Judge.
What, do you know the?
Me?
But either, what?
So what he tells me in terms of the, I guess, potential tampering, he said was, the device was wet around his skin. So he used, in fact, he told me yesterday, he used a leaf blower to dry it off. That may have been one of the times it was tampering.
That wouldn't cause a tamper. Environmental factors like that don't cause something like that, and that would be such a short period of time. I have the durations of the hours on that little sticky note, and I can't remember them off the top of my head. But tampers are confirmed after 8 hours with low alcohol detected, so therefore a leaf blower wouldn't. If anything, it would show a spike in tamper, but nothing to cause a tamper.
So what we have here and what I have here, your first tamper was on October 28th, and it was in an 11-hour tamper. So more than likely, what we find is that people put things in between the scram device and their ankle to subvert the machine. Your second violation that we have is on November 11th at 3 a.m, and that one is a 9-hour tamper. How does that happen?
I have a explanation.
So Judge, the only thing I have is the violation report. I don't have any other documentation from you guys showing exactly, well.
The problem is that there's only,
But in terms of saying that it was for 11 hours.
I have the scram report, counsel, I can send it over to you. if you'd like.
but, and if you want to take time to look at it, but what we find, it's really, there's no cameras. So it's impossible to really look at what they're exactly doing, but all we know is that they're breaking the continual skin and device contact. And how they're doing that, I wouldn't know. Only he knows. But all we know is that the tamper is for a duration because the contact is lost somehow. Piece of paper, could be that they're using a sock, however it may be. But all we know, it's for a certain duration and that it's a tamper and it remains constant for that entire period. So the machine is not able to test his leg.
Okay, yeah.
So I'm happy to give you the device. You will stay with me now and take a
I'd like to
and
look
tell
at
me
it and talk
what you
about
think. Yes.
exactly what.
Yeah, I mean, I'm not letting him go.
I understand.
Okay.
Okay, so. I'll
So
get that and then I'll-
we'll give you the info now. I'm taking you into custody right now. I'll let you talk. I don't want him to go outside.
I understand. I understand.
But I'll give you more than enough time to talk.
Sure, okay. Okay, we'll talk afterwards.
Yep.
All right. Sure, and